Justice Gorsuch?
Just a couple quick questions more. Sorry.
No.
922G3 has two prongs, as we've discussed. One is you're an unlawful user, and second is you're an addict. And you prosecuted Mr. Hemani only under the first prong, unlawful user.
Correct.
You're asking us now to understand that prong to mean an habitual user.
Correct.
What's left of the second prong? Do you render it superfluous, given that an addict is defined by the statute as an habitual user?
So two pieces of this. One, it's not superfluous. An addict is someone who has an uncontrollable urge to use this substance regardless of whether they have access to it at a particular moment in time. You can be an addict and not be an unlawful user because, for instance, you're in a treatment.
Well, I thought the CSA definition of an addict was any individual who habitually uses a narcotic drug so as to endanger the public morals, health, blah, 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 blah.
Yes. So the second part of this is, I think respondent is being very careful to say we're not actually, no one thinks that that is the actual operative definition. I don't think you could because it says narcotics. It is obviously not the definition that Congress is using. It's limited to narcotics for the purpose in the Controlled Substances Act of dealing with treatment facilities. So the ordinary meaning that's been adopted by the government with dictionary definitions and all the courts of appeals is not that. It does cover both concepts. It covers unlawful user is someone judged by the objective criteria of their frequency of use. An addict is someone who has an uncontrollable urge. They can overlap, but they are also there are situations, as perhaps here, where—
I've got it, thank
you.
And then secondly, your backup argument is, well, maybe Schedule 1 and 2, we really need those, but not Schedule 3 and the rest of the schedules. If that's the case, what do we do with this case, given that, yes, it's presently a Schedule 1 drug, but the government itself is considering rescheduling it to a Schedule 3 drug? Why bring this case? Why is this the test case?
Why is this the test case? I mean, one is that, first of all, at the time when the offense was committed, marijuana is and was a Schedule 1 drug. Two is the government has not made final decisions with respect to what to do with marijuana, but I think something that is clear from the NPRM at least, again, bracketing like what happens in ensuing stages, is that even Schedule 3 drugs, which include things like ketamine, the difference is they have some medically accepted uses, not that they're not dangerous, not that they don't present—
No, I understand that's your primary argument, is they all count.
That's
your backup argument is, we'll stop at Schedule 2, I don't know why, but okay, but the drug that is involved in this case might wind up being a Schedule 3 drug tomorrow.
Yes, I understand that, and I think what I'm saying is not so much there's like a hard and fast, like special magical Second Amendment rule that says Schedule 2 and no further. It's just if you wanted to sort of set if you wanted to rule out like Schedule 5 or Schedule 4 for Ambien, the cutoff with respect to dangerousness like does diminish, and I think the court could say you could bracket potentially as applied challenges if you wanted to do that. I'm just saying this is a fallback that's not the government's main position, but I think when you see the way the scheduling works and the statutory criteria,
I understand that. It's just an odd case to have chosen to test the principle when the government itself is potentially rescheduling it as a drug that it wouldn't think would qualify under at least its backup argument.
I think we would not concede that it wouldn't qualify. I think the government has to make a decision with respect to the risk potential of marijuana and other externalities, assuming, again, this is a process that has not yet unfolded, which I can't commit to any result.
Thank you.